After the many crimes of the Second World War, the states across the globe wanted to reaffirm the universal character of the right to life and the fact that the protection and the guarantee of the right to life is the cornerstone of human rights. This is very clear, and it would apply to every human being. Now we see an attempt to reintroduce within this right distinctions between human beings that would guarantee the right to life only to a limited scope of human beings, those who are already born and who are in good health. So we see a very dangerous attempt to reintroduce an ideological bias that would destroy the universal character of the protection of the right to life, and at the end that would make people vulnerable to the desire of others to end their life.
On the question of the exclusion of the unborn from the right to life, we asked Rita Joseph for her opinion. She's an Australian academic, writer of the book on the protection of the unborn.
I found the historical evidence of the formal recognition of the unborn child as a member of the human family. Article 55 of the founding charter of the United Nations says that human rights belong inherently to all without distinction. While drafting Article 6 of the Covenant, the only recorded attempt to introduce abortion as an exception to the right to life occurred in the Working Group's second session, 1947. It was put to a vote and was resoundingly defeated. A principle was adopted in which the only exception to the unlawfulness of the deprivation of a life was to be in the execution of the sentence of a court following on conviction of a crime for which the penalty is provided by law.
Tom Finegan, an Irish academic who obtained his PhD in Trinity College, Dublin, fully concurs with Mrs. Joseph.
What's also clear from an examination of the UN documents and the treaties, and especially also from the preparatory work that goes into the drafting of those treaties, is there's absolutely no such thing as a right to abortion of any kind. If the human rights law says anything, it's that the unborn child ought to be protected against threats to its well-being.
To justify abortion, some scholars or national courts tried to develop the idea that human beings and persons are two different realities. They say that the fetus is a human being but not a person, so that the right to life would not apply to him. We asked Josh Craddock from Harvard Law School, who wrote an article on the 14th Amendment of the US Constitution, for his opinion on this distinction.
In my research, I looked to dictionaries of common and legal usage at the time of the 14th Amendment's adoption in 1868, and I found that they used the terms person and human being interchangeably. So the original public meaning of the term person included every member of the human race. I also looked at centuries of common law precedent and state practice leading up to the 14th Amendment's adoption, which also indicated that the unborn were considered legal persons. Finally, I looked at the authors of the amendment and found that they expected it to protect every human being, especially the weakest and most marginalized. So that original expected application was indicative of the original public meaning and demonstrates that informed citizens believe that the text of the 14th Amendment in the U.S. Constitution applied to every human being without exception, whether they were born or unborn.
Interestingly, when you look at the human rights treaties, and I think this is contained in the International Covenant on Civil and Political Rights, one of the rights is there that everyone, which means every human being, has the right to be regarded as a person before the law. There is no dichotomy, there's no divorce between them, and I think that makes sense. To be a human being is to be a person.
However, the Human Rights Committee published in July 2017 a draft of its general comment. In paragraph 9 of this draft general comment, the committee not only denies human rights protection to the unborn, but it also promotes a right to abortion as enshrined by the article protecting the right to life. My reaction is that they really had
got it just so wrong. It just didn't fit in with the rest of the general comment. It's like it's written in another language. First of all, I would say that pregnancy should be safe for mother and the child. There's two patients there. And that's the problem. What has happened in this paragraph 9 is the unborn child has been deleted. This paragraph 9 comes at it from a point of view of an extreme feminist reinterpretation of human rights. The right to life applies equally to the child before birth as to the child after birth. And really, we can't change that without changing the whole basis of the human rights system. What is happening here is that the Human Rights Committee is actually introducing or trying to introduce an amendment to the right to life.
Paragraph 9 also goes against the United Nations Declaration of Human Rights in Article 3, which says that everyone has a right to life. There is no international binding covenant or treaty that requires states to permit abortion. And so the idea that this is premised upon that states can't outlaw abortion is completely wrong. There's nothing in the treaty that says that. And so this rapporteur's interpretation runs counter to everything in international human rights law. And in fact, the weight of evidence in international human rights law is that every human being is protected.
Well, I wasn't surprised because the Human Rights Committee for a long time now have been trying to develop their own, what they call jurisprudence on this matter. So they would say something all of a sudden out of the blue that there is such a thing as a right to abortion in certain circumstances. They wouldn't be able to refer really to any part of international human rights law because there's no such thing as a right to abortion there. And they couldn't obviously refer to the preparatory work that went into making up the drafting of these documents. So they've just, I suppose, proposed this, and every time that they come back to reaffirm that proposition, they've just referenced themselves. So it's problematic. But these committees themselves don't have the right under international human rights law to develop or delete or add to legal human rights provisions already agreed to by sovereign states. In my article, I've collected various citations where pro-choice scholars recognise that committees like the Human Rights Committee don't have the authority to develop or add to or even authoritatively interpret binding human rights law.
So abortion in international law, according to the intention of the writers of the Universal Declaration of Human Rights, was clearly an exception to the right to life and a kind of evil that is tolerated because of the will of the Soviet countries in that time. At the opposite, during the Beijing and Cairo conferences, states agreed to say that they have a duty to reduce the recourse to abortion, and that abortion should always, as much as possible, be avoided and never promoted as a means of family planning. This is the same as the Court of Strasbourg, the European Court of Human Rights, which always refused to say that the unborn child has no right to life. The Court of Strasbourg always refused to say that the unborn child is not a person. Indeed, it did declare that the states can, if they want, recognize that the unborn child is a person and enjoy the full protection from the European Convention of Human Rights. So clearly there is this recognition. As well, the Court of Strasbourg always refused to declare or to recognize any right to abortion stemming directly from the European Convention of Human Rights. It did say, indeed, that there is no right to abortion stemming from the right to privacy or to autonomy. That there is no right to receive abortion, no right to practice it. So in no way abortion is seen as a right by the Court of Strasbourg, but as a kind of exception tolerated by the court if there is proportionate reasons on the side of the mother or of the state. but no right per se to abortion according to the Court of Strasbourg.
Sovereignty is probably the key principle when it comes to international human rights law on the question of the unborn. States generally have a high degree of latitude in trying to decide how to best protect the unborn child in that regard. At the same time, there are elements of human rights law that also clearly do protect the unborn child. For instance, the unborn child is protected from the death penalty by the International Covenant on Civil and Political Rights. The unborn child is also protected in the preamble of the UN Convention on the Rights of the Child, and the unborn child also has some protection even according to the International Covenant on Economic, Social and Cultural Rights when it comes to healthcare and the reduction of the stillbirth rate and the reduction of infant mortality.
No UN Human Rights Committee has any authority to divide the human race into into persons and non-persons. There's no authority to do that anywhere. It was always agreed right from the beginning, every human being has the right to life. That was universally agreed.
In the international space, I think it's likely that pro-abortion groups will continue to try and use special rapporteurs and comments on treaties to try and push for abortion, contrary to the intent of what the treaties actually state, because they know that they can't get enough support to actually enshrine abortion as a right within an international treaty or convention. So these sort of manipulative tactics, I think, will continue, and it's up to us to try and point them out and to resist them.